Controversial COVID lawyer Rocco Galati's counsel argued in court that he should not be personally liable for costs after his $1.1 million libel suit against the Canadian Society for the Advancement of Science and Public Policy was dismissed, reflecting a division within the movement opposing pandemic public health policies. In February of 2024, the Ontario Superior Court Justice Chalmers ordered Toronto-based notable COVID contrarian lawyer Rocco Galati to pay over $132,000 in legal costs after his libel suit against a group of opponents with more professionally drafted litigation of vaccine mandates was dismissed. The defendants in that case were the British Columbia-based advocacy group called the Canadian Society for the Advancement of Science and Public Health Policy, acronymed CSASP, and namely its founders, Kipling or Kip Warner, Dee Gandhi, as well as former client of Galati's, Donna Taves. They successfully argued that Galati's $1.1 million lawsuit against them infringed on their freedom of expression. In Chalmers' initial decision from December 2023, he notes that Galati originally claimed that defamatory comments were made about him, which have affected his reputation and interfered with his relationship with his clients. It was claimed that this affected fundraising efforts undertaken by Galati's organization, the Constitutional Rights Center. Chalmers relayed in the decision the way the plaintiff was conducting litigation regarding the government-imposed restrictions enacted in response to the COVID-19 pandemic. The defendants maintained that the harm likely to have been suffered by the plaintiff does not outweigh the public interest in protecting the expression, which Chalmers ultimately sided with. Basically, the defendants felt it important to bring the various issues with Galati's court filings forward to the public. Galati's appeal of Chalmers' decision and the costs he was found to be personally responsible for argues that his libel suit was improperly dismissed, claiming that the defamatory statements were not true and mischaracterized. His lawyer, Paul Slansky, asserts that Chalmers conducted a superficial analysis, failing to consider the public interest or the sting of the statements, such as allegations of fraud, dishonesty, and professional misconduct. It was hard to follow a cohesive line of thought, but I believe Slansky ultimately argued that hyperlinks provided to Chalmers by the defendants did not support the defamatory claims, and that Chalmers erred by excluding malice and not addressing the public nature of the dispute, which ultimately undermined the defamation case. The respondents argued that the appellant's legal actions, that's Galati, including a series of extreme and reckless allegations made in various court filings, which have raised large sums of money from hopeful litigants, but ultimately resulted in a waste of court resources. They criticized Galati as both a poor lawyer and advocate, using intemperate language and bizarre claims that have been repeatedly struck down by various courts. That's their own words. The most notable case was struck as recently as December 18th, 2024. It involved 473 healthcare workers across Ontario who were fired or placed on unpaid leave for refusing to take the COVID-19 injection. The defendants were majority hospitals, including administrative staff and some government officials, like Premier of Ontario Doug Ford, former and current health ministers, but it actually refrains from naming Chief Medical Officer of Health Dr. Kieran Moore, whose Directive 6 is referenced in the claim as it mandated COVID vaccine policies in healthcare settings throughout the province. The defendants filed a motion to strike, which was argued in August 2024, and the decision was filed, as mentioned, on December 18th, striking the claim and ordering nearly $200,000 in costs against the ousted healthcare workers. Justice Conan ruled that the court had no jurisdiction over the case due to a lack of authority over unionized employees and privilege claims under the Public Hospitals Act. The action was deemed an abusive process, with the scope of the case being impractical and prejudicial by combining 473 individual cases. The pleadings were considered frivolous and vexatious, with an overly complicated statement of claim, including unavailable remedies like administrative declarations and injunctive relief. The claim was criticized as unusually drafted at best. While the justice does discuss judicial notice, which means that the courts accept without question that the novel, modified RNA-based COVID-19 injections are safe and effective, I think there is space for that record to be corrected, but it must be done so professionally, reasonably, and with comprehensive, clear evidence. Justice Conan says Gulati's statement and amended statement of claim contains few material facts about the employment of any of the nearly 500 plaintiffs or the circumstances of their suspension or termination. It also includes unnamed and improperly listed plaintiffs, notably several identified plaintiffs who do not appear to have been employed by the defendants at the relevant time of vaccine mandates. In one instance, hadn't been an employee since 2007. The justice ultimately ruled that there was no reasonable cause of action. It's also noted that the claim is riddled with mistakes, roping in federally mandated travel restrictions and vaccine passports for air travel into an Ontario-specific judgment. While I don't believe that justice is correct in asserting broad statements like there's no known immunity to contracting the virus, there's no verifiable evidence of natural immunity to contracting the virus or any mutation, a second or more times, vaccines work, it's been made clear that this approach is not the right one. Justice Conan concludes the judgment by claiming that the statement of claim is outlandish and far outside of the spectrum of what is reasonable, that there is no legitimate public interest in its pursuit. If this was not clear from the outset, it should have been clear by the time the British Columbia Supreme Court, the British Columbia Court of Appeal, the Federal Court, and the Federal Court of Appeal struck out similarly drafted statements of claim prepared by the same lawyer. While the interests of a free and democratic society may warrant leeway with respect to the pursuit of unconventional claims at the outset, when such claims continue to be pursued after being struck out by 4 courts, they amount to an abuse of public resources. Now, I reached out to Gulati with questions around the decisions against him, including how he responds to concerns about statements of claims being outlandish, unreasonable, and lacking jurisdiction in the courts where they were being filed. He responded that all COVID cases have been dismissed outright so far, claiming his cases are the only ones left standing with leave to amend the pleadings and still in court. He asks why I'm not writing about other lawyers and plaintiffs who have hit brick walls with their litigation, ignoring the fact that I have, and says that citing judgments out of context is a cheap game. He furthers that the courts are clearly bent against anyone challenging the COVID narrative and have abandoned the rule of law, evidence, procedure, and rationality and simply asserting through judicial notice, which I touched on before, without the need to test any of the scientific or medical evidence, that everything is safe and effective. Why, he says? Because the government simply says so. The Supreme Court of Canada has not weighed in on any of the COVID issues, especially the vile infringement of constitutional rights. Many courts in the USA and in Europe have gone the other way than Canada. Are those judges and courts from another planet, or do they have a COVID-19 we have never heard of here in Canada? I responded with additional requests for clarification to see if Gulati was involved in some of the cases which are proceeding to trial, such as the one involving Sean Ricard and Carl Harrison, who will have their lawsuit against the government's vaccine mandate for travel heard in the federal court after a motion to dismiss it was rejected. And this one, where a federal court of Canada judge declined to dismiss all claims in a proposed class action filed by federal employees who alleged they were unfairly penalized for refusing the COVID-19 vaccine. I asked if it was fair to assume that Gulati will be amending all previously dismissed proceedings, of which I believe there are 5, and if so, what is the timeline for them? What will happen to the unionized employees who aren't subject to the leave to amend in the latest December 18th decision? Gulati responded that this is just incredible. You are so under and ill-informed. It is beyond the pale. While I appreciate that there is a need for contrarian lawyers like Gulati who continue to challenge COVID-19 policies, and he may be right that the courts are biased, it's hard to properly test evidence when you can't even get past the statement of claim process. For Rebel News, I'm Tamara Ugolini. Canadians deserve a government that is efficiently run and financially accountable. It's time to cut the waste and reshape how we fund the bureaucracy in this country, having politicians that serve the people, not corporate interests. If you agree, head over to slashthebureaucracy.com and send an email to Conservative leader Pierre Poilievre urging him to take bold steps towards reforming Canada's bureaucratic system. That's slashthebureaucracy.com.